Something extraordinary has just unfolded, and the political world is struggling to process it. Moments ago, former national leader Daniel Trask lost operational control of his iconic coastal estate, Harbor Crest Manor, after a federal judge issued an emergency seizure order. The decision came with stunning speed, arriving barely 5 minutes before news agencies picked it up. And as if that was not shocking enough, one of the world's most respected financial minds, billionaire investor Walter Brentford, broke his long silence and delivered a statement that has sent tremors through global markets, private equity circles, and the entire political landscape. The federal seizure is being described by legal scholars as the most dramatic property intervention in the history of the country's modern political era. Officials working within the Metropolitan District Attorney's Office, in cooperation with federal financial regulators, executed the order with precision and no advance warning. According to investigators, this case is not just about a single property. They believe it represents the unraveling of an entire network of financial misrepresentations tied to Trask's empire. And the timing could not be more explosive. For years, Harbor Crest Manor has served as the central hub of Trask's post office influence. It is where allies gathered, where strategy meetings took place, where donors arrived with million-dollar checks, and where Trask cultivated his aura of authority long after leaving national office. To understand the significance of what has just happened, it is crucial to recognize the role Harbor Crest Manor played in Trask's political and financial identity. Since early 2021, nearly every major political figure within Trask's circle made a symbolic visit to the estate, hoping to maintain his favor. It was a headquarters, a strategic command center, and a symbol of power. But that era ended today. For 6 months, prosecutors have been quietly building a case centered on alleged financial misrepresentations involving the valuation of Harbor Crest Manor for tax filings and commercial loans. According to court filings released today, investigators claim that Trask listed the property as worth 1.74 billion credits when applying for large institutional loans, yet valued it at 24 million when reporting taxes to local authorities. Experts reviewing the documents say this discrepancy far exceeds typical valuation differences and suggests the kind of deliberate inflation and deflation pattern seen in major fraud cases. It would not be a minor paperwork conflict. It would be classified as intentional deception. The investigation began at the state level but expanded rapidly after federal regulators discovered potential links to interstate financial violations. According to officials, the pattern extended beyond Harbor Crest Manor and potentially touched other Trask properties. Judge Selena Marquez, a respected jurist known for her firm and impartial approach, issued the emergency seizure order at exactly 2:47 p.m. Eastern Time. The order froze the property and transferred full operational authority to a court-appointed financial receiver. Trask is barred from holding events, conducting political operations, or accessing restricted areas without direct supervision. Federal marshals secured the ballroom where a major fundraising event had been scheduled for tomorrow night. Sources close to the investigation say Trask's financial situation had already been more precarious than previously understood. Analysts from multiple business publications noted that his liquid reserves had dropped sharply in recent years. Many of his assets were tied up in heavily leveraged buildings, golf resorts, and licensing ventures facing increasing legal pressure. Harbor Crest Manor was reportedly one of the few remaining properties that produced consistent revenue. Losing control of it could cause cascading financial consequences. The seizure documents state that Trask engaged in a pattern of fraudulent valuations that harmed financial institutions and violated federal banking standards. Judge Marquez wrote in her opinion that the evidence suggested willful disregard for legal and ethical boundaries in pursuit of personal advantage. Legal experts said this was unusually strong language for a sitting federal judge, indicating the seriousness of the findings. In a rare move, she even scheduled a public statement for tomorrow morning, which analysts interpret as an attempt to counter any misinformation or politically charged allegations that may arise. According to investigators, several major banks finally cooperated after years of reluctance. Leaked internal communications show that some executives privately questioned the accuracy of Trask's financial statements, but continued approving loans due to anticipated profits. One executive wrote that the valuations appeared unrealistic, but that the institution stood to gain significantly from processing the loans. This revelation has sparked additional inquiries into whether financial institutions enabled or ignored questionable practices in exchange for lucrative returns. Trask's initial response followed a familiar pattern. He publicly denounced the investigation, calling it unfair and politically motivated. He vowed that his legal team would dismantle the case, but sources close to his advisors say the confidence began to fade as more evidence surfaced and more institutions provided documentation. Then came the statement from Walter Brentford, the billionaire often nicknamed the Sage of Silver Ridge. Brentford is known for avoiding political commentary entirely, preferring to focus on long-term market principles and ethical investment philosophies. But today he said, when you build a financial structure on misrepresentation, you eventually encounter the consequences. Business should be built on trust, transparency, and real value. He revealed that his firm had been approached years ago about potential investments in Trask-affiliated properties, but declined after reviewing the financials. According to Brentford, the numbers lacked the stability and integrity expected in sound business environments. This statement alone reframed the national conversation. Observers note a long pattern within Trask's world. Former allies often remained close until they refused to cross a legal or ethical boundary. After that point, they found themselves criticized or distanced. Political analysts argue that the same cycle is now repeating itself, but with financial backers, legal teams, and institutional partners instead of political appointees. Legal scholars compare the scale of the seizure to landmark cases from the 1980s, when law enforcement targeted large criminal networks. Conservative legal experts, who rarely agree with aggressive government intervention, have stated that the evidence appears substantial and may be difficult to refute. Some suggested that Trask's legal team may attempt to argue selective enforcement, though the success of such a defense seems improbable given the magnitude of the discrepancies. Trask now faces a defining choice. His political base expects him to maintain his image as a fighter who never yields. But protecting his remaining assets may require negotiating, admitting to irregularities, or accepting significant financial penalties. These strategies conflict with his public persona. If he continues fighting, he could lose more properties or face criminal charges. If he compromises, he risks damaging the identity that supporters have grown to expect. Complicating matters further, several prominent donors have already paused contributions to organizations associated with Trask. They state that they cannot support a figure facing serious financial allegations. Political strategists warn that if additional donors distance themselves, Trask's political influence may weaken rapidly. This entire situation raises profound questions about financial accountability and the rule of law. For decades, the nation has prided itself on the principle that no individual stands above legal standards. If someone can manipulate financial systems without consequences, it undermines public trust in the justice system. Many citizens may not fully grasp complex election laws or national security protocols, but they understand the basic idea of misrepresenting the value of a house for personal benefit. It is a simple concept, one that resonates across political divisions. As the legal battle intensifies, the next several weeks will determine not just the fate of Harborcrest Manor, but the broader implications for political accountability and financial ethics. Appeals will be filed, supporters will rally, critics will analyze every detail, and the justice system will face one of its most significant tests in recent memory. The outcome will shape debates about fairness, power, transparency, and whether influence can shield someone from responsibility. The stakes are enormous, the evidence is mounting, and the nation waits to see how this unprecedented conflict will unfold.